Welcome to Family Law Matters, the podcast presented by the Mealy Firm. Visit www.allfamilylaw.com or call 866-687-8561 to learn more. And now, here's your host.
Welcome back. Again, my name is Bill King with the Mealy Firm, and we are here today to talk about what keeps our clients up at night. And this is your Family Law Matters podcast where we talk about family law. And so I'm excited to have in the studio with me here two of my great colleagues, Emily McClarty and Julie Watkins. Emily is an associate with the firm, and Emily is in her first year of practice, and so she has a great perspective on coming into family law and learning it as a new practice and seeing, what fears our clients have. And then Julie is a paralegal, but she is also our paralegal manager, and she has a wealth of knowledge and great experience, and we're just excited to have her as part of the team. And again, we're going to talk about what are our clients' biggest fears, what keeps our clients up at night. And we often talk about several things when we're talking about what our clients focus on when they're going through a divorce or legitimation or custody action or whatever it might be within, under that family law umbrella. The three things that we talk about that is a client's focus is time, money, reputation. Somewhere across that, spectrum or that, thought of what are the things that they think through and what they're dealing with, normally their fears fall under one of those categories as time, money, or reputation. I think money and reputation is self-explanatory, and we'll talk about that, but time. And when I think about time and when I think about what are our clients' fears is time with their children and how these cases are going to impact that time with their kids. What are y'all's thoughts?
I think not only the time with their children, but the processes effect on their children and how their children are mentally and emotionally dealing with the split up of the family.
And I think that goes to, don't be afraid to reach out to a therapist for your children. Don't be afraid to take it off of yourself. Don't make it mom versus dad. Let the therapist talk about it. Let them engage the children and work through it.
Right. So engage experts. So don't think about it as something that you've got to handle all the time. I mean, give yourself some grace because you are going through a very difficult time in your life. You don't have to be perfect all the time. So maybe take a step back and think through, if I can't do this for my children, who can I bring in to be able to do that? And we, those experts out there that are able to do that. And we have a big vendor list of preferred vendors and people that we trust to refer out to. And that includes family therapists or, children's therapists to be able to talk to the kids and work with them on what they might be going through. So in thinking through that, when you're working on a case and you're seeing what a mother or father might be going through, but you're also seeing what the kids are going through, what is the conversation like with the client when you're saying, hey, this is what you might need to do? What's your approach?
I think when I start talking to them, I let them know it's important to have these conversations with your children. Don't ignore the conversation. Approach it head on. Sit down with them, schedule a time, maybe in a comfortable location, take them out to dinner. Don't make it this daunting task for you or the children. Allow that comfort space to fill the room and allow them to be comfortable and just let them know things are changing. Life isn't going to look the same. I don't love you any less. I love you just as much. Your mom or dad loves you just as much. We're just going to be spending a little time apart, and it's just going to look different day to day on where you're going to be. But our family dynamics aren't going to change in terms of who loves you. Yeah.
I love that thought. And one of the things that I think our approach is with the firm is that when you walk through the door, we're not just thinking, okay, we've got to get a divorce. We've got to get it done. We do think through what impact not only is the process having on our clients, but how we relay that information to the clients, right? So it's more about thinking through the impact not only of the process, but the impact of how the information lands with our clients, and how do we deliver that information?
I think another thing is to reassure your children that none of this is their fault, and that neither parent is to blame the child. And allowing your children to have their feelings and to express their feelings, whatever those feelings may be, whether it be sadness, anger, resentment, they're allowed to have those feelings.
Yeah, absolutely. All right. So outside of the impact on children and those thoughts, the emotional side, when you are talking to clients about the legal process, okay, what does it look like when we are arguing for custody? What does it look like when we're thinking through the evidence? What do you all look for when you are meeting with clients or when you're working with clients in terms of developing or gathering evidence?
I look for long-term intent. Are you going to stay here in the state? Do you want to move out of state? Do you have a place to live? Are you living with family? Are you going to get your own apartment, your own home? Are you going to have bedrooms for the children? What schools are your kids in? Are we going to keep them in the same district? Are we going to try to maybe travel a bit more to accommodate the fact that they may be in the same district? And trying to keep the children's lives as stable as possible while figuring out how best to allow both you and your future ex-spouse to still have that time with the kids.
So not to get into the legalese too much, right? But we have, the best interest standard. What's in the best interest of the child? And when you're looking through that, there's a lot of categories in the statute that we look at, and we say, okay, you can look at this, this section of the statute, this section of the statute, and determine where does that evidence fall within that statute? Where are they going to go to school? Where are they going to live? But one of the biggest things, and what I'm trying to get to, is co-parenting, right? So when you're thinking through that and you're having that conversation with a client and you're saying, these are the things we need to think through from the top, we are assuming both parties are going to co-parent and work together for the best interest of the child. That doesn't always happen, though. And so you're dealing with maybe two parents who are not co-parenting, or one parent that's not co-parenting. Maybe it's our client, maybe it's the other party. And so when you're working through that and you're thinking through, okay, best case scenario, everybody's going to co-parent. We can have these conversations and be reasonable and rational about these. But when you have somebody on the other side that doesn't co-parent, or somebody who is unreasonable, where does that steer you in terms of your conversation with the client, and again, what evidence you're looking for when you're going to go before the court?
So for me, it's more if it's our client who is not acting in the best interest of the child, or maybe not co-parenting the best, sometimes you have to have a hard conversation with them and have them try to step back and look at this objectively in what's best for their children. You have to remind them that it's not mom against dad. That's not what we're here for. We're here to find the best resolution for the children. And they need to put their animosities aside to try and do what's best for the children. Now, if it's the other party is not helping to co-parent, then we would need to start gathering the evidence that we would need to prove that in court, such as text messages and or visitation schedules or calendars, those kind of things. Who takes the children to the doctor's visit? Who is there for the parent-teacher conferences and things like that? Who is molding these children's lives on a day-to-day basis? And how do we keep that consistency for those children?
Yeah, I heard you say text messages and things like that. And so what I always tell clients is get it in writing. Get it in writing.
Everything is better in writing because the judge, it's he said, she said, unless it's a paper trail. You can't fudge a paper trail.
Right. Exactly.
So, and I always try to tell clients, please keep track of everything. If mom or dad is late for visitation or they cancel at the last minute, keep track of those things over the course of your children's visitation life, so to speak, because those items can come back and later help you if you're doing a modification 5 years from now, or dad's being unreasonable or mom's being unreasonable. You have those messages from 3 years ago to back up what you're trying to prove now. So it's better to keep more records than less.
Absolutely. And I always tell clients, whether you're in litigation or not, whether you have an active case or not, always act like the judge is sitting over your shoulder reading what you were typing and what you're about to send to the other party. Would you be okay if this was going to be read aloud in a courtroom with the judge going, that's interesting?
Myself, when I went through my personal divorce, my mother gave me a great piece of advice. And it was, would you feel comfortable with these text messages, and back then it was emails, being read in church in front of everybody?
That's another way to take it, too.
She said, if you would feel comfortable, then send it. If you would not, then don't send it.
Yeah. And so I think that is a good segue, and we'll continue to talk about the impact, because I really think one of the biggest nightmares for clients is the impact of this process on their children, and I want to get back to that. But to the thought of, would you read this aloud in church, is we talked about time, money, reputation. That would go towards reputation, right? Is, would you be okay with your neighbor knowing, or your friend, or church knowing, or having a sense of what's going on in your divorce, or what's going on in your custody case? And so reputation is a big piece of what people are thinking through in terms of, how is this divorce going to impact my future, whether it's your reputation in your community or at work or, amongst your friends, whatever that is. And so thinking through that when you're having conversations outside of, about children and how that impact, when you're talking to clients and thinking through that, what are some of the things that you all talk about? And I'll tell you, one of the things that I tell them is, look, this is a judgment-free zone when they're in my office. And when they come in, I say, we have anything that you tell me is confidential. It's privileged information, unless it's discoverable and unless it would need to be revealed in order to further your case. But it's confidential and it's privileged. And so when they're thinking through, how is this going to impact my future, my reputation, what I try to tell them to get them to open up is, I'm not going to judge you. I can't tell you how many people have sat across from me and the things that I've heard. And look, it's your life. You're in here bearing all. At least hopefully you're bearing all, because there's nothing worse than being surprised by a fact when you're walking in a court or somewhere that you've never heard before. But this is a judgment-free zone. Don't worry about your reputation or what I think. This is, again, a judgment-free zone. What is that? How are your all's conversations when you're talking to clients about that?
Similar to that, we discussed the good, the bad, and the ugly. I want to know everything good about your life. I want to hear the stories of you and your children. I want to hear what's been going good. I want to hear what's been going wrong. How can we adapt our legal plan to accommodate what's been going wrong? Is there a lack of communication? How can we build something into your parenting plan for your child so that there's better communication there? There's problems with trying to make decisions. We put provisions into our parenting plans to accommodate those difficult decisions. So walking them through, we can help accommodate the bad, but you need to let me know what it is so that we can discuss it and see if it's something that we can further achieve.
I always like to let people know that we want to know the bad up front so that we can get in front of it. And we want to be proactive, not reactive. And we want to be more offensive than defensive. So if there is something that's going to come out, whether I'm looking through your bank statements or your taxes or things like that with your discovery documents, be honest with us, because we can attack it differently if you're honest. The last thing we want is something for the opposing counsel to bring up that we don't know about.
Yeah, and I like that you said we want to know the bad up front, right? We make no qualms with telling clients, look, this is going to be a difficult issue, but we don't want the opposing counsel to be able to hang their hat on that issue. And so it is better for us to know it and to get into the courtroom and to tell the judge, we know this is not a great thing, Judge, and this is how we're going to handle it. It takes the wind out of the sails for the opposing counsel, because if they're building up this climax of their trial, and you get to that point, and then they go, boom, here's the smoking gun, and then they win their case on that smoking gun. If we're able to address that earlier on, if we're able to put that into the, get that out there in front of the judge and say, Judge, here's the main issue. Here's the bad or the ugly with our client, but here's all the good, right? So you lay out the bad and then you go, but here's all the good. So I love that. That's great. So time, reputation, money. Money is a big stressor in what keeps clients up at night. When you are talking to the clients, what do you get from them when they're talking about money, and what do you talk to them about and help them through with that?
When we're going through the divorce process, there's something called equitable division, which is where can we put you and your future ex-spouse where you're both going to be in a financially secure position moving forward, given what you have accumulated within your marriage. So we discuss, do you have a property, bank accounts, 401ks? Do you have a job? Are you a stay-at-home parent? And a lot of times people are concerned, am I a stay-at-home parent? Do I have no income? But the courts view that as a job. That is a job to raise your children. And so not to be concerned with the fact that you're a stay-at-home parent, that's perfectly acceptable.
And kind of encouraging them to sometimes take control of their finances. And sometimes in a marriage, one person has control of the finances and someone else has no idea what's going on in the finances, and kind of directing them to some of our resources as far as financial counseling and guiding them to owning their own finances and not counting on somebody else, and reassuring them that they can do this. Because I think that's a major fear is, can I do this with the money I have? And can I financially do this? Raise my children by myself and things like that. So reassuring them that the court is going to look at this and they're going to provide for you and your children in a way that's along with the legal guidelines.
Right, and the legal guidelines. So going back to stay-at-home mom, one of the things that we work through is alimony or spousal support applicable in this case, and then what does that look like in terms of how many years are we going to ask for it and how much are we going to ask for those years? And that varies, obviously, from case to case, but we take that into consideration when we're looking at a stay-at-home mom or dad and looking at, disparities in income and length of marriage and all those factors that go into it. So it's something that is very top of mind for us when we're looking at, what does the money look like in this situation? Same thing with one person has had control of the finances, the entirety of the marriage. You're right. We do suggest maybe financial counseling. We have financial advisors that we refer to. I have a buddy from college that comes in and we do a series for our clients, and he talks in that series about, financial awareness and what you can do in terms of being better about, handling money. One of the other things that I want to talk about, though, is difficulty in selling houses out of a divorce, because a lot of people have homes that they got at such a low rate when they purchased, during COVID or just after COVID. And now people are going through divorces and they're going, well, I want the house because it's got a 2 whatever, mortgage rate. I don't want to have to go buy another one and get a rate at 6.9 or 5, 5.9, whatever it is. When you are thinking through that, have you dealt with that with clients? When you're thinking through that, what are you all working through with them?
For me, it's more, we look at it and my question to them is, can you afford this house on your own? Can you afford the payments? Can you afford the insurance? Can you afford the maintenance? Is that something you want to take on by yourself? And especially when you're being, if you're a first-time single mom, you're going to have a lot more responsibilities because you're going to have expenses now that you didn't think about. Sometimes you don't think about, now I have to have my own car insurance. I have to have my own health insurance. I have to have my own cell phone plan. Bills that were a group, or a couple bill is now my single bill. So really trying to look at the house finances and look at it realistically to see if this is an option for you or is this not the best option. Is holding on to the house your best financial option?
And at times, sometimes I advise clients to see if renting is an option, at least short term. Take that time to accumulate what you need to be able to put a down payment down on a property, or to kind of wait out the market, see if the interest rates are going to come down in a year or two, and just give it a little bit of time. I don't rush into anything too fast. It's okay to take a step back and take a year to rent.
On top of that, or in addition to that, one of the things that we think through that we should talk to them about is when you're going to purchase a new home and when you're looking at the rates, you have the option to buy down the rates, right? So it could be, set at a 6.9. But on the front end, when you're paying closing costs, you can pay an additional $10,000 or $15,000 to buy down that rate. And so thinking through that when we're negotiating and saying, well, we're going to sell the house and split the proceeds, or this person's going to keep the house and buy your share out. But thinking through that this person's going to have a 2.9 rate, and we want to try to equalize that when this person is moving out, then maybe instead of saying, okay, if there's $300,000 in equity in the home and you're going to get 150 and you're going to get 150, well, this person should get 165 because they're going to take 15,000 of that and buy down the rate to get a rate that's closer to what you have, and that makes it a little more fair. And so understanding that notion or that idea and being able to talk to clients about that to help relieve kind of some of those fears about, well, I'm not going to be able to afford a rate like that, additional things to think through. So absolutely thinking through what are all their finances going to be, thinking through, do they need to rent for a little while to save up, or thinking through how do we creatively negotiate in order to get them into the best situation possible. All right, so we've talked about children, we've talked about reputation, we've talked about money. One of the things that I think a lot of times goes unnoticed is the idea of the death of the marriage, because everybody's so focused on litigation and sometimes so upset at each other that they don't have this notion or idea that the marriage is dying and they are losing time, not just with their children, but time with a loved one or somebody that they have spent so much time with, and the memories that they've shared with that person. And so when they're going through that loss, I try to work with them and talk to clients about different emotions and what's going on. But outside of that, one of the things that I see or notice is sometimes they will transfer that relationship that they had with that spouse or that loved one, or that emotion that they had with that loved one, to us. And so instead of getting mad and arguing with their loved one that, or whatever emotions they were feeling, they can sometimes project those onto us. How do you all work through that or deal with that?
I come at it with just a sense of understanding. Tell them, I understand this is probably one of the most difficult things you are ever going to go through in your life. I understand your emotions. These are natural to feel. Take a moment to sit here, reflect on them. What's causing them? Let's see if we can address them head on and kind of talk them out for a moment, and then kind of get back into how can we build this divorce to obtain the best outcome for you.
Also letting them know that what they're feeling is natural, and they're going to go through a roller coaster and a gamut of guilt, regret, they're going to mourn the death of their marriage. So there's a whole spectrum of emotions that they're going to go through, and it's okay to feel those. And let's try to turn them into something positive and productive. Yes, you're feeling this today, but we still have to soldier on and move on through it. And you will get through this, because there is a light at the end of the tunnel, and there is life after divorce. And you just kind of have to embrace it and use that as your goal, is, to get through this process and move forward.
Right. It's giving clients a bit of grace and letting them work through those emotions. I can't tell you how many times I've been yelled at or cursed at, sometimes even threatened, and just understanding at times that it's not me. It's not something that I've done. It is what the clients are working through and trying to deal with all of these changes, because change is scary. And so thinking through that and working through that can create those extreme emotions. And so again, going back to just giving the clients a bit of grace and understanding what they're going through, and understanding it's not me. And it's not them. It's the situation that has created all of these emotions, and letting them work through that. So, all right. So what else? So thinking through what keeps our clients up at night? What else do you all see when you're working through cases?
I hear a lot recently about, well, he or she said that I'm going to get nothing from this divorce. They told me I'm never going to see my kids again. It's kind of a manipulative mindset. And so I tell clients, take a deep breath. Let's talk through why that's not correct. Let's talk through the law. Let's discuss, what are you eligible to obtain legally? Custody of your children. Let's talk through what that's going to look like. No, you're probably not never going to see your kids again. Don't allow that bullying narrative to kind of take over in your mind. Stand your ground. Say, I can do this. I understand my rights, and I will see the light at the end of this tunnel.
I think the other thing is people have a misconception of how a divorce is going to go, whether it's going to be 30 days, whether it's going to be 60 days, or it's a divorce like I saw on TV, or my friend's divorce went this way. Every divorce, every case, legitimation, whatever, is unique. And you can't set a calendar and you can't set a timer by how things are going to go. And just because your friend's divorce only took 60 days does not mean that your divorce is going to take 60 days. Or my friend did this and this, why can't we? Every case is different. Every county is different. So just knowing that we operate in every county in Georgia. So we kind of have more experience than your best friend's wedding or your best friend's divorce, in a county that we've been in for years.
Yeah, and to that end, I mean, we have 6 offices around the state. We have attorneys that work in different geographical areas, so they have that knowledge of the courts in that area and what's going to happen. And so we try to strategically set it up such that we have an idea, but you're 100% right. I mean, we don't have a crystal ball. I mean, if I had a crystal ball, I don't know if I'd be here, right? If I could see into the future, I love what I do, but if I had a crystal ball, I might,
lottery numbers.
Yeah, I'd be jet setting across the world, but we can't see into the future. And so thinking through how do we strategically best set that up? We try to do that. We have the geographical locations. We have attorneys that focus geographically in areas, so they have a better understanding of the locale and what the judges are like in that county and things like that. But it is hard to predict the future, and I get that. And clients are always worried about, was this going to be 6 months of my life? Is it going to be 2 years of my life? Can I get this done in 30 days and move on? A lot of people, not everybody, but a lot of people, I don't want to say want to stick their head in the sand and ignore it, but they want to lift that burden off of them, and they want to know, when is this going to be done so I can move on with my life and I don't have to feel this way anymore.
And I think another good part is, one of the things that we do is we try to educate our clients on the steps. This is what we're doing now. Here's the next step, and here's the next step, and here's the reason we're doing this. And we keep them up to date as far as, what is the process of the litigation? Why are we going to mediation? What is discovery? Why do we have a guardian? So that they understand what is the process, so they don't have the misconception of, oh, we're going to mediation, we're going to settle. Not always. So it just depends upon the situation.
Yeah, and one of the things that I love that we do, that we've implemented or started doing, is status letters, right? And so we provide letters or emails or phone calls, but something to the clients that provides them updates on what's going on in their case and what they can expect next, so that they aren't in the dark and they aren't blindsided by something that's coming along in their case, and they don't know, and they feel hopefully more comfortable, hopefully more settled, hopefully more educated in what they're going to see and what they're experiencing. And going back to what you said earlier is about people who say, well, you're never going to see this kid, or you're not going to get anything out of this divorce. And I know this is maybe a little cheesy or cliche, but I always think through, and what I talk to clients about is, the law is not about vengeance or being vengeful. It is about justice and trying to make somebody whole if there's been an injustice. And so when people think about that, a lot of times that's kind of a personal injury concept, because they've been injured and you're trying to make somebody whole. But when you're going through a divorce and you're thinking through, how do I try to make somebody whole? That's where the notion of, equitable division comes in trying to do what is fair given the circumstances, trying to provide for each party based on what has occurred during the marriage and what is resulting in the end of the marriage, right? When you are working through kind of that equitable division, I know we talked about, we're going to look at all the bills and see that, but when you're looking at the equitable division and looking at everything, what are some of the things that you all implement or work with clients on in terms of looking through that and trying to help them understand, here's how things may go in terms of making you as whole as possible when you leave this, when this process is over?
One of the biggest things I see clients ask about is, well, what about my retirement account? And so that becomes one of the things that comes into play when we discuss the equitable division. And part of it comes in, how much of that did you have prior to you getting married? And how much of that have you accumulated now that you're in the marriage? And of course, that will make a difference as to what can be divided.
Right. You're talking about like separate property, premarital property versus marital property. Yeah. Yeah.
And so when we're talking about the equitability, the retirement accounts are often a bargaining chip on how, well, you can take the car, but I'll keep my retirement account. It's that precious asset that so many people want. And so I look, if that's somebody's main focus, to try my best to preserve that and see what we can leverage that might not be so important to you, but that we can keep the thing most important.
One of the things that we use that is a great tool for the paralegal side of this is we do what's called a marital balance sheet. I list husband's debts and assets. I list wife's husband's debts and assets. And we look at that and try to equal it out so that it is equal. But we can see everything in a snapshot of what's on one piece of paper, and we kind of make those adjustments so that when we go into mediation, we have a starting point. The other thing that we hear a lot of is, well, my name's not on the house. Am I eligible for part of the equity in the house, even though my name is not on the house? So it's a lot of times it's educating our clients on their financial assets and their debts, because they don't quite understand, if my name's not on the debt and I'm not making the actual house payment, am I still eligible for part of that?
Yeah, I actually hear that all the time. As somebody comes in and they say, well, all the assets are in his name. The house is in his name. The cars are in his name. The bank accounts are in his name or her name. And they're like, I'm not entitled to anything. Well, that's not true, right? So anything that's accumulated during the marriage, regardless of how it's titled, is marital property and subject to division, such that even if you're not on it, you should still receive a portion or your share, your marital share, or what's equitable in the divorce. All right, we focused a lot on kind of divorce and the custody part, but we also do legitimations and paternities and contempts and things like that. So one of the things that I think keeps our clients up at night is what happens if they don't abide by the agreement or the court order. When we're thinking through what are the remedies to that, or what do you do if they don't pay me child support, or what happens if they don't pay me the alimony that they're supposed to pay me, or what happens if they don't sell the house and split the proceeds? What do you do, or what are your answers to clients in those situations?
So with regard to child support, one thing I let them know is, well, let's go back to court. Let's file a motion for contempt. And the court has the ability to apply what's called arrearages, which is to get you the child support you should have been paid in addition to the child support that needs to be currently paid. And the court is able to garnish wages from a job, should that be necessary. They're able to, in a sense, order that they will take these funds and you will receive them.
Right. So additional orders, like an income deduction order that goes to the employer that automatically takes the money out and goes directly to you, so you don't have to rely on the other side to pay you every month. That's certainly an option. And with the contempt actions, the court does have a number of remedies, including jail time. If it gets to that point, if it becomes that egregious, to put the other side in jail. And that's always a balancing act, right? Because you kind of think through, well, or if they're in jail, how are they going to pay you? Or how are they going to go to work and make the money to pay you? So it's always a balancing act to know how that plays out. But with that said, that remedy is there to say, I'm going to put you in jail until you what's called purge yourself of this contempt or what's owed, and pay what's owed or do what you're supposed to do. On your side, Julie, when you're talking to clients who are dealing with what if they don't do this or what if they don't do that, what are some of the things that you've seen or worked through?
Well, we look at exactly what they're in contempt of. So the first thing we're going to do is look at the original order. And then we're going to need proof that they didn't follow the order. So, for example, if they haven't paid child support, I'm going to look for, I need to know when they paid, what they paid, and how much they paid. I need a record. I need backup. Have you talked to him? Have you communicated with him or her? Have you tried to, communicate directly to them to resolve this issue? Because that's something we can take to the court to show that we attempted to resolve this issue outside of the court and the other party is not complying. And then, we can always, seek make-up visitation. If you're being denied visitation, we can seek make-up time. We can seek, financial adjustments such as child support, alimony. We can also request attorney's fees to help offset the cost of filing a contempt because the other party did not follow the rules and the orders. So I think for those cases, it's more of, it's less gray area. It's more of a black and white. You were ordered to do this. You didn't. Here's the repercussions. So those aren't as wishy-washy as some of the other issues that we have, and there's less gray areas.
Yeah, and when you're talking about bring me the proof and show me this, and so we can put it together, what I hear and what sparks my interest and my excitement is organization, right? I love organization. I think that's the best. So being extremely organized when you're walking into the courtroom, and so working through and laying out all of that evidence, making sure that it is organized such that you can present it to the judge and the judge can easily understand it. Because what I work through with clients is, and I'll talk about this in a second with mediation, but you have spent hours, days, weeks, years dealing with this or working through this. You're going to go in front of a judge, and the judge is going to hear from you maybe for an hour, maybe for 3 hours, depending on the case. It can be more or less, but the judge is going to sit and hear your case for maybe 3 or 4 hours, maybe a day, maybe 2 days. But you have to take all of this information, all of this evidence, and condense it down into a day's worth of information. And so organizing it such that you can present it to a judge efficiently and effectively is at the top of our list at the firm, right? To make sure, we have trial binders that are organized, to make sure we're walking in and we're handing the judge all the information the judge needs. The more organized it is, the more efficiently and the more effectively we're going to be able to present the case. And so in terms of gathering evidence and what you're thinking through, what do you all talk to clients about in terms of what they need to be able to get us, and so we can effectively and efficiently put together the evidence and present it?
For me, it's like, for example, visitation. I want a visitation calendar. I want to see, one of the things I suggest clients do is, okay, your case is over. Start keeping a diary. Start keeping a journal, for the next 18 years or forever, how long you need to have a custody situation. Keep track of when the party is late bringing the children back. Just keep a written diary type thing, so that way you can remember those things. Text messages, emails, those kind of things, because those are, here again, paper is going to be much more impactful than a testimony.
I ask for photographs. I want the photo of you and your family to show the judge, this is what we're dealing with. This is the children at stake here. Look at them. See, this is not a piece of paper. This is someone's life. And to try and draw out that emotional but still legal ability to move the case along. Right.
They're not just names on paper. This isn't, some abstract thing. These are real people that with real consequences of decisions that are being made. And I think it does, we have a lot of great judges in each of our counties that we practice in that do great jobs. But I do really think when you're able to be able to put these photographs of the children and the families in front of the judges as your initial exhibits, it really is impactful to show the judge, here's faces that go with these names, here's events that go with these families, here's happiness and joy that these families have experienced, and showing the judge that, whether it's your initial exhibit that you're presenting to the court, or at least at the beginning of your case, showing the judge those things and then going into it is a great idea. And we do, in almost every case, ask clients to provide us some photographs of you and the children, so that way we can show the judge, this is the family that you are going to be making a decision about, right?
It personalizes it.
Yeah, absolutely. And so, again, I just get giddy when we talk about organization because it's just my thing. But, I think it is so important to be as organized as possible. And so working with clients to get all that information and get that in, and to be able to condense it down and present it to the court. When we're working through the trial binders and you're thinking through how are we going to present this case, when you are talking to clients about here's what I need, and you've told me that, I hear exhibits and I hear trial binders and I hear pleadings and I hear contempts and I said earlier, I don't want to get into the legalese. One of the other things, and I want to end on this, is when we're talking to clients, I think one of the things that keeps them up at night is just not understanding the process. All these big legal words and exhibits and contempt and petition and arrearages and purge amount. What is your process in terms of working with clients to help them better understand the process, and to not knock away or push aside, but to get underneath all the legalese or all those words to help them better understand and feel better educated about it, so they are not staying up at night, not understanding?
I break it down, even from the start when I have my initial consultation with somebody. They discuss discovery documents. I break it down. There's two kinds. You have interrogatories, you have requests for documents. This is what you would expect in each of these documents. While you are pursuing this, start considering, how would I acquire these documents, so that you kind of get the mind going. But breaking it down, asking them, do you have any questions? Is there anything I can explain further for you? Do you understand what document I'm asking you to review? Do you know what a complaint for divorce is? Can I explain why it's kind of at a 10,000-foot level and why it's not incredibly detailed to your case? What can I do to make you understand?
I think for me, it's more of an educational. I try to explain to them what each step entails, what the document is that they're receiving, and why they've got it. What is an entry of appearance? What does that mean? Why who is this other attorney? This is your opposing party's attorney now. And try to put it in terms that anybody could understand. I try to pull a lot of the legalese out of my emails and my correspondence with the clients, so that they understand that, hey, we're all just the same people. It's just different words.
Right. Exactly. Trying to help clients feel more comfortable through education of the process, through education of the language, through education of what ultimately their lives are going to look like when this is all done. Well, thank you both for joining us on the podcast today. Again, this is Family Law Matters with the Meneely Firm, and thank you to Emily and thank you to Julie. And we'd love for you to check us out and get a little more information. So go to our website at www.allfamilylaw.com, and we can't wait for you to join us again.